Let's now get onto the phone line still and speak with Sammy Obeng from the African Parliamentary Network there. Sammy, good to have you on the lines. Thank you so much for joining us. This is where we find ourselves. An arrest warrant has been issued for the arrest of a member of parliament because he has been cited for contempt of court. And we know how the case has progressed up until now. What does this mean in parliamentary parlance?
Well, good morning to you and your listeners. We have a member of parliament who has been duly sworn in parliament. Prior to his swearing in, the implications of what could go wrong were made known to him. And speaking through the leader of his caucus, he elected to go ahead and face the consequences thereof, if any, because the clerk of parliament, as you have already read out the provisions of, I think, Article 105, which speaks of the Constitution. So we are talking about Constitution, you're not even the standing orders of parliament, which speaks to what happens if you sit, vote, participate in a parliamentary proceedings knowing that you are not supposed to. Parliament went ahead to swear him in, and he's a member of parliament serving the people of Akwatia. The courts have issued a warrant for his arrest. We also know that now that he's a member of parliament, the rules relating to parliamentary privileges and immunities applies. Which means that he cannot just be, arrested, so to speak. Fortunately for us, there is a tidier arrangement between the judiciary and the legislature on how to effect the arrest or how to, deal with members of parliament when they are facing some of these issues in court. Right. The Speaker has spoken extensively to it. The judiciary, through the Chief Justice, has issued some administrative directives in relation to that. And so we'll expect that they would go through that particular process. He would subject himself to the court for the sentencing that needs to follow the conviction to happen. These are all processes that are steeped in law. The Honourable Member of Parliament was aware of these, and because of that, I'm sure that he and his lawyers, together with leaders of his caucus, will be looking forward to going through the process as it is. And for us, it serves a very important standard based on what happens with this particular case, on how we proceed as a country, on election of members of parliament and swearing in, because if the chronology of events is anything to go by, we know then that in subsequent parliamentary elections, it's very likely that such things will happen. And depending on how this particular case gets treated, we will now have members of parliament elect and their caucus leaders being either cautious on the decisions they take on the 9th of swearing in, or perhaps, leaving it to chance, citing this particular case as a precedent. Because what is the chronology of events? Elections take place. Electoral Commission declares a particular candidate as having won. The Constitution is clear that if you want to challenge the election of somebody as a member of parliament, you go to the High Court. So the other party goes to the High Court. They only do not go to the High Court on application, but they also ask the High Court to injunct the person declared as having won from holding himself. The person comes to the High Court proud to the swearing in to say, I want to challenge this. The High Court says, no, we are affirming our position on the matter. And this only happened on the 6th of January. The High Court affirmed it. He decides that, well, despite the High Court's decision affirming this the afternoon of the 6th, I will still go to Parliament later that night to be sworn in. Clerk of Parliament reads the relevant provisions to him, and the fact that they've been said, he says through his minority leader that, look, I'll go ahead to get sworn in and face the consequences thereof. The court says you have disobeyed us, and we will fine you for contempt of Parliament. It is important that the court, we know that the courts would like to assert its authority in matters like this because they will not want to leave some of these things to chance. Other than that, in the future, there will be instances where people will disobey the court with blatant disregard. And so the court, in wanting to assert its authority, would want to do something about it. But for me, the most important thing is that this case, depending on how it goes, will help set out the parameters around which members of parliament who have been elected, yet their seats are being contested in court, to know how to hold themselves prior to swearing in.
The minority in parliament, they say that they will come out with their full position after they've received a full briefing from their lawyers. Talk to us about how this could have been handled differently. My colleague Sisters is making the point that both sides of the House, the majority and the minority, they could have reached a certain compromise so that we don't get here.
Well, I also hold the view that we could have not gotten here. This was avoidable. Why? Because, from a neutral, common sense position, the numbers in Parliament on the 9th of, on the early mornings of the 7th of January,
right,
would not have changed anything without him, being sworn.
True.
And his caucus would not have lost anything.
Right.
The decisions that were taken on that particular morning would have stayed. Maybe the politicians knew a lot more on why this should have happened that way than we know. But sitting behind and determined, this is not a case of 7 January 2021 when you knew that just a single individual could change the entire dynamics, right? In this case, the number differences were so huge. And so just waiting a couple days, to avoid some of these things, in my opinion, would have been the most appropriate thing. But remember that he spoke through his minority leader, who is an astute lawyer, who is the same person who yesterday granted that very short interview and said they would speak to the lawyers, get a full briefing, and they'll come out appropriately on the subject matter. Hopefully they have some actions under their sleeves that they would want to put out. But this could have been completely avoided. And I think that the outcome of this process should serve as a lesson to the various political parties, the various individuals who put themselves up for elections as members of parliament going into the future, so that you don't put yourself in such an uncomfortable situation simply because you decided that you cannot wait a few more days.
Sammy, maybe finally, before you take leave of us, for the constituencies that are still in dispute, the Ablekuma North constituency, we still do not have, if you like, an MP there, and then the constituency for the Honourable Frank Anodompreh. Although this may not be the same circumstance, but are there lessons for these disputed constituencies and their member of parliaments to learn from?
For those that are in dispute because, members of parliament have been declared and others who disagree with the decision have taken it to court, remember that this is something that has been with us for a while.
Right.
And while we remain a human institution, we would have these things going on and on. At every point in time, people will challenge, and that should be fine. You go through the legal processes. If you're exonerated, you continue with your work. If you're asked to get out of parliament, like in the case of Mr. Kwesi, you get out of parliament and whatever happens following. So for me, I have no issues with that. In fact, my only concern would be the time frame, so that these challenges in the High Court do not linger on forever. Because we've had instances where, the court case goes on and on and on and on. And by the time the court will probably determine the issue, it would have been a wasted, effort, because whoever had won, if the person was not a legitimate winner in that election, would have served a full 4-year term and no justice would have been served properly, to the other person who brought the case to court. My concern is with Ablekuma North. And I think it's completely untenable, completely unacceptable that the people of Ablekuma North, with almost 2 months into a new parliamentary tenure, do not have a representative. That's tens of thousands of people who've been denied representation in parliament simply because an electoral commission and police decide that they are unable to do the work that they are mandated to do because a group of people will come mess things up. If we live in a country where tens of thousands of people will lose their rights to representation because our security forces and institutions that have been mandated to do their work cannot go ahead to do their work with the forces of the state being used to protect the sanctity of that particular process, then we are in real danger. We spoke at Parliamentary Network Africa against the fact that SAL did not have a representation in Parliament for 4 good years, and the same principle applies. We cannot have the people of Ablekuma North sit on tenterhooks and not have their representation in Parliament. What this means is that the people of Ablekuma North have not participated in the people who have become ministers of state and deputy ministers in this country. The people of Ablekuma North have not had their voices heard on the major decisions that have been taken by Parliament so far. The people of Ablekuma North have not had questions and statements that relate to their constituency put across on the floor of Parliament thus far.
Right.
The people of Ablekuma North have not participated in who is holding himself as Speaker and Deputy Speakers in this nice Parliament. They've not participated in that particular process. They've been left out and will continue to be left out so long as the Electoral Commission, the police fails to do their work. And we all appear to be silent about this, allowing the politicians to play their regular politics and allowing state institutions to pass the buck and put the blame on others rather than doing their job. This is completely unacceptable.
So, although I said finally, maybe this one is finally. The Akwatia MP, Ernest Kumi, he was in Parliament yesterday, although he spent very few minutes there. With all the happenings around him, should he still be coming to Parliament?
Well, the many lawyers have spoken about this. We've heard how matters relating to contempt needs to be dealt with so that you don't find yourself in even deeper waters. We've even seen how contempt of Parliament itself, a way of approaching it. If you are charged of contempt of Parliament, how you approach it so that your issues do not get compounded. And so to stop him from compounding his issues, it will be great for him to take steps that convinces the court that he's not willfully disrespecting the court, its decision, its authority, and what have you. And that's why, as a first instance, it was quite refreshing to note that perhaps upon getting into the chamber yesterday and the information getting to him, he decided that he would, at least if the news report is anything to go by, he would leave the chamber, not participate in the proceedings of yesterday. We don't know what's going to happen today and the days that follows. But I think, and this is based on my own understanding from what lawyers have explained, that it will be appropriate that he takes steps to convince the court that he did not set out to disrespect the court, so that he will not be in even deeper waters going forward.
Sammy Obeng, we thank you. Thank you so much. Sammy Obeng is the Executive Director of Africa Parliamentary Network there.